All right, good afternoon, everyone. Welcome to our Re-Parole webinar part 2, Implementing the Process. My name is Becky Blenderman from ILSAA, and we will go ahead and get started here today. We have a very full agenda. So welcome to everyone. I see folks are entering the room, so I'm going to give folks just a minute. I see folks coming in the room. We'll give folks about 30 seconds and then we will get started. Good afternoon, everyone. Welcome to our webinar, our part 2 webinar on Re-Parole, what's happened and what we know now. My name is Becky Blenderman from ILSAA. I'm going to get us started. We have a full agenda today. Let me get started by giving just a couple of housekeeping pieces of information to share before I turn it over to our speakers, excuse me. So first of all, our webinar is being recorded so that you have it available for future viewing. We'll send out the link after the training to this webinar. This will be an interactive webinar. You're going to have the opportunity to ask questions. I am going to ask you one thing, and that is that you kind of hold your questions. We have a lot of material to cover, so please hold your question. You can actually type it in the chat, but don't hit send until the end if you don't mind, and we will track all the questions and try to get to those by the end of the session today. If you're having any technical issues during the webinar, please send a private message to Bridget Ott. Her name is here on this slide, and we will do our best to assist you. Again, you can send her a private chat. And most importantly, at the end of the session today, you're going to get an evaluation link and presentation slides. We ask that you please fill out that evaluation link. It's very quick, about 1 minute, to give us some information that we want to learn more about as we continue to provide webinars for you in future months. All right, so let's go ahead and get started. Our agenda for today, these are some of the things we're going to cover. We'll do a quick introduction of our speakers, and then we're going to jump right into our topics around re-parole, a little bit about what the need is and what we know now for numbers around applications. We're going to talk about some of the expected challenges that are being addressed, some common FAQs that we've heard, common scenarios and solutions, just recent information that we've learned over the past few weeks and months. And we will close by giving some resources for you to leverage, a Q&A session, and then closing. So that is our agenda. Our presenters, we have 2 presenters for you today. The first are 2 presenters are Rebecca Watson from ILSAA, the Immigration and Legal Services, and Adonia Simpson from the ABA Commission on Immigration. So with that, we will jump right into our agenda for today. And I will turn it over to you, Adonia.
Thanks so much, Becky, and welcome everybody to today's webinar. It's been really interesting the last few weeks and several months as we've been tracking the information. I think we've been very fortunate to have a lot of stakeholder engagement with USCIS, so we are regularly learning new information. And actually, since we put together this slide, we have heard new details about some of the latest numbers. But a previous engagement, we learned that there was about 19,000 individuals who had not applied for any permanent immigration benefit. So that means somebody that has not applied for either, asylum, which is going to lead to a pathway to permanency, or adjustment of status. There was also estimates about 14,000 who had just applied for TPS. And as you all know, TPS does not have a pathway to permanency. There are issues around benefits for individuals that have TPS. So there really is a need for folks to get some sort of permanency, on a pathway to permanency. But in the interim, these are the population of individuals that really need to be considering applying for parole affirmatively. Since these numbers went up on the slide, we actually did get more details. Latest reports, there's about 17,000 individuals who have not filed for a permanent benefit. So we are seeing those numbers go down, which means that there's more and more people that are applying for asylum or adjustment of status. And, even as we discuss discuss Re-Parole today, it's critically important to be talking to your clients, to applicants or individuals that you're assisting, to make sure you're exploring eventual permanent pathways and helping them down that road, and really using Re-Parole as a stopgap to ensure continuity of status and continuity of work authorization. We also have some numbers up here on this slide with some of the number of pending asylum applications and pending adjustment of status applications. As you can see, as the numbers go down on folks that haven't applied for benefits, we are going to see increases in those other areas. So that's just the latest on numbers. I think it's really helpful to set the stage as we explore, what population is going to be getting some sort of extension that are going to be, automatically evaluated on a case-by-case basis for a parole extension, and who is going to have to affirmatively apply. So we've been seeing a lot of challenges, and it's really around the communication of what's happening with work authorization. On our last webinar that we had last month, we had a ton of questions about, how is this working? We had some guidance from I-9 guidance that's going to be changing. We anticipate will be changing soon. But let's talk about some of the challenges regarding work authorization. Right now, processing times in general, what we're seeing is about 1.5 years for renewals based on pending asylum and adjustments. But we are seeing expedited EAD processing under C11. Also, C8 initial pending EADs based on a pending asylum application are being processed really quickly, particularly for those individuals who are filing online. We can't recommend it enough. We had a case where essentially at the 180-day mark, that case was adjudicated. So the C8 EADs are processed pretty quickly, and also expedited processing for the C11 EADs. So we really, when you're looking at your client's case, you're going to want to make sure, and it's going to be one of the biggest questions they're going to ask you, is just to ensure that there's continuity in their ability to work. So there was a lot of confusing information around how this whole extension re-parole process was working in regards to work authorization. So for individuals that have received the extension, they will be receiving a 797C that will address that 790C parole extension. It's going to give instructions on how to update the I-94 parole document, but it also provides instructions to employers that extension, in combination with an expired work authorization, will allow them continued work. We are waiting for additional guidance that should be coming out from USCIS, guidance that's facing towards employers, but also guidance that will be facing towards the Department of Motor Vehicles in your different jurisdictions, ensuring that people are still able to access not just their employment, but also some sort of driver's license or identity document issued by the state. Really encouraging, when this guidance is issued, to make sure that your clients have this information and they're able to pass it along to their employers to show that they are authorized incident to this parole. And again, we have received communications from USCIS that this will be clearly outlined on the 797C. Something else that we've been seeing a lot of is that we have been seeing employment authorization documents that were never corrected. Perhaps they were issued initially upon entry, following parole into the United States. These work authorization documents may have errors. Maybe it's perhaps an error in the date of birth, in the spelling of the name, maybe even an error with the photograph. We've seen all of those things. And when it comes to work authorization, people should be really ensuring that work authorization document is correct, that all the biographic and demographic information, the information regarding your client, is up to date. So we wanted to provide you some information about the process for correcting that work authorization. You do not need to submit a new 765 or pay the fee. There's some instructions here for Afghan nationals on how to correct the work authorization document. When you receive these slides later, you can click on this and go directly to the hyperlink, and the documents you'll send this information to the address listed here. We really encourage you to make sure that these work authorization documents are updated. When you're doing the affirmative re-parole application, sometimes the best evidence is the work authorization document. However, if there are any errors on that document, you're going to be looking at other identity documents that you'll want to file with the I-131 in order to establish identity. So best thing to do is get this corrected, make sure that your client's identity documents are all correct, all up to date. And then before we jump on to the next slide, one more thing that I wanted to add. We've also heard of lots of issues around the parole documents not being correct. Perhaps it's the wrong class of admission, or maybe there's some other sort of error on the I-94. And the email, there's been some discussions, there's various emails. And Rebecca, did you hear back from your team about what the most current email is?
I think the general guidance that I've seen and what I've been using is looking at the local CBP office in your state. My most recent emails to this OAW email have received bounce backs, but that was about 6 months ago, so I'm not really sure. But if anybody else has a specific CBP email that they have used in their area that they found to be very responsive, please share that information and kind of share that with your other legal service providers as we continue to find the best ways to connect.
Absolutely. And as mentioned, this email address that's listed on the slide was provided in an earlier stakeholder engagement. There's been some other email addresses out there. I think one of the difficulties in having this opportunity to have so much engagement, there's a lot of information that's out there and circulating. And like Rebecca said, if you all have the most current email and it has worked most recently in recent time for you all in updating any issues to the I-94, please let us know. And it looks like Jill Marie put in the chat a link to the CBP online form and maybe a Google Doc. So please check out that chat. We'll make sure to include it or that link in the chat for additional information. Thanks so much, Jill Marie. Next slide. All right, we covered this a little bit, but I wanted to take a little bit of a deeper dive and spend a little bit more time talking about the work authorization, kind of challenges. Even when we receive guidance from USCIS and I-9 guidance is updated, and it's made very clear that individuals who receive the extension on their parole are authorized to work with that 797C and expired work authorization document. We do anticipate that there may be issues with employers who maybe aren't quite familiar with that. You'll want to make sure that your clients have access to any sort of employer-related documents that they can take with them. But sometimes it might just be easier, and some people may prefer to go ahead and file for that new and updated EAD card. So that is also always an option, but please keep in mind, according to guidance that we've received from USCIS, as well as that's forthcoming on I-9 and other areas, that 797 extension notice, along with the expired work authorization, should be sufficient for employment purposes. And people do not have to apply for an updated physical EAD card. However, it is fee exempt, so somebody should choose to go down that path, and you have the resources to assist them. We certainly encourage you to do so, but it is not required. So some other updates that we've received recently following the work at the Afghan Support Center last week, we did hear reports that USCIS has started sending these 797C notices. They're going out to the applicants, the individuals. If they have a My USCIS account, it will be uploaded there. I think, Rebecca, are you going to talk a bit later about the courtesy notices to attorneys?
Yes, so that'll be slide 11, a little preview of what we're getting into.
All right, so little teaser there. Stay tuned for Rebecca to discuss a little bit more for all of you advocates how you can ensure to get that information that your client will be receiving directly on their My USCIS account. If your client does not have a My USCIS account, it will go to the last address on file. So again, really important reminder, make sure that the addresses are being updated for your clients so that USCIS does have the most current address. You don't want those documents being returned because unknown address. So as mentioned, we have received reports that these notices have started going out. We'd love to hear from all of you if any of you have actually seen one or received one. As I mentioned earlier, USCIS has indicated that they have updated the language on the 797C to include information about obtaining the extended I-94, the new I-94, and then also explicit guidance to employers about the ability to work and work authorization. We did also hear information from USCIS that the way that these cases are being triaged, these individuals who do have a pending immigration benefit. So again, this is the automatic piece. These are individuals who have a pending I-485 adjustment of status application or an I-589 asylum application or their derivatives. These individuals will be automatically reviewed for consideration for an extension. So they are being triaged based on the parole expiration date. Excuse me. I think we'd heard some reports that might be on the date that an application for a particular benefit was filed, but it has been confirmed that one of the biggest factors in this triage process is the date that the expiration of the parole. So hopefully that means that individuals who have parole expiring in the coming weeks or month will really be receiving those notifications, those 797Cs to either their MyUSCIS account and address or just their address if they don't have a MyUSCIS account. So there was a lot of discussion amongst providers about timing on if you do have to file. If you do have to file the I-131 for any reason, how soon and how early is it? USCIS has given guidance that they will be evaluating it based on expiration of parole. So, for example, if you do have somebody whose parole will be expiring in 2024, perhaps in early 2024, USCIS has indicated that those individuals can file. They just won't be probably processed right away, and it will be processed in the order of expiration so that there is no harm in filing early. I know amongst a lot of legal service providers, we've been discussing that, are you potentially losing 6 months by filing now if it was to get adjudicated, and you would maybe be losing a potential additional 6 months of parole status. But from indications from USCIS, it seems that they won't necessarily be processed right away, that they are really focusing on individuals whose parole benefit will be expiring in the coming weeks and months.
Great. So I'm popping in to talk a little bit about some of the two main pieces of guidance that we've received from USCIS. So these are kind of recurring issues that they've seen and kind of proactively wanted to address in terms of issues with our re-parole filings. And the first one is they're seeing a lot of translated documentation, such as tazkeras, that are being submitted without the official translation certifications. So just like any other filing with USCIS, like with an asylum filing or your adjustment of status filing, you really want to have, for any document in a different language besides English, you want to have all three pieces of that puzzle: the scan of the original document, a translation of that document into English, and then the certification of translation that goes along, just verifying that the person who translated it is able to translate and all of that. So very similar to any other form of application that you're submitting with USCIS, the same holds true with documentation for these re-parole applications. The next step, and I think this is largely just an issue with paper filings, is making sure that the code is correct. So the code of admission, if it's OAR, PAR, whatever it is on the I-94, as long as the I-94 is correct, to make sure that that is accurately reflected on this application. To my knowledge, this is kind of preset on the online applications for re-parole, but this is an issue that we've seen. Sometimes people have left it blank or things like that on the paper applications, and that will throw an error, cause issues with USCIS when they're processing these paper forms. And again, if there are corrections that need to be made, please contact either this email address or your local CBP office, and they should be able to help you walk through the steps to update an I-94. I'm seeing in the chat that this email doesn't work any longer. I have had great success reaching out to the local CBP office for where I'm located, or where the client is located, rather, to see if they can do it directly, if it needs to be closest to the client's port of entry. But thus far, reaching out to the local CBP offices has been really helpful. And I know Jill Marie put into the chat the link to that CBP outreach form. And on to the next slide, please. So now we're moving on to a lot of the common FAQs that we're seeing, some of which we have some guidance and insights to. So the first one is requests for biometric appointments and medical forms. If people are missing some of their medical records or weren't initially gone through the main medical process when they came to the US, case by case, they will be notified in writing if they need to get additional medicals done, get vaccinations done. I personally have not run across this yet. So if someone has, please bring it up at the end for discussion time. I would like to hear any specific experiences with people having medicals be a reason for an RFE or a delay to being able to apply for re-parole. What we do know is that formal form I-693, that medical examination and vaccination record would not be required, but I personally have not come across this with any of my clients, so I haven't seen it hands-on what this medical request would look like. In addition, I want to address an issue that is at the top of a lot of people's minds right now, is what happens if, particularly for people who don't have auto parole underlying, if your initial parole expires while re-parole is still pending. So an individual comes to you, they file August 31st, and their parole is set to expire, say, September 2nd or September 3rd. As of middle of 2 weeks ago, last week, USCIS announced that applicants who have the My USCIS online account who applied for the I-131, 765 can check the My Progress tab and see a personalized estimate of their wait time, including the final decision. So I think this is very new and, to my knowledge, really only applicable to this re-parole application. That they will be able to see on their online account progress as the application is being reviewed with an estimated time of the final decision, which I wish I had for every single case. And I think that's really exciting to see, and I hope is expanded throughout. So I don't know if this has been launched yet, but I'm hopeful that it will be reflecting on people's accounts as soon as possible, because I think that will provide a lot of kind of baseline understanding of where their application is at in the process. In addition, we have other challenges that we've seen that we've addressed slightly, and some that we're going to address right now. So any name and spelling inconsistencies between EADs, other documents, what you're applying for the re-parole application, typically pretty remedied if the applicant's EAD has the correct name and date of birth. That's generally the controlling document for these applications. If not, if we're seeing multiple inconsistencies, if you could get the EAD corrected first, that's great. And if not, you may need to submit some supplemental documentation clarifying that, just to make sure these applications get out the door. In addition, we're noticing some people have been getting paper receipt notices for paper filed applications pretty quickly, and some have noticed significant delays. I know throughout my office and some of my colleagues, they've seen faster responses for regular USPS mail than first class or certified mail. That could just be anecdotal, but if you're tracking how long it's taking for you to get your receipt notices, I think that would be very helpful to get a general sense of, are we seeing 5 to 6 days? Are we seeing 2 to 3 weeks? These things are really good to know, just so we have a general sense and a general estimate. We're also seeing a lot of issues with individuals getting locked out of their My USCIS accounts, because there are so many different steps to creating this. The email account with that password, the My USCIS account with that password, and the multiple different kind of security questions, security codes that go with that. So if there's any possibility, if you are setting up a My USCIS account with a client, to sit side by side and draft out all of that information that they're putting in to make sure that they have it both in their hands and can take a picture on their phone so they have that reference point. It's, to my knowledge, not possible at this time to get into a fully locked out My USCIS account if you don't have the password, if they can't remember the not referral codes, the security questions. If you don't have that backup code written down, it's still a point of technical issue that USCIS is still working to build up. I have tried through my attorney account to reach out to My USCIS if I have a pending application that is locked that needs to be released, and that has not thus far worked for me, but it is an issue that USCIS is aware of and actively working towards finding some other backups and other ways to help people get into a locked out account. But for now, the best thing that we can do as legal service providers is make sure that we have all of that information written out for clients, both that they can have in hand and have a picture on their phone, just so there's multiple ways to cross-verify. And then finally, a very interesting issue that we have seen kind of across the board with receipt notices that we have received lately and that we're starting to see is receipt notices that say, yes, the application is filed, but there is no valid G28 on file, even if the attorney submitted their G28 alongside it. This is an issue that I know was raised directly with USCIS this past week in Pittsburgh, and they are now aware and actively looking into this. To their knowledge, that doesn't necessarily mean that your G28 has been severed from the account, that there's going to be any lack of communication to the attorney when an actual approval is issued. But please let us know if you are starting to see that on your receipt notices, that the receipt notice says no valid G28 on file. And if you and or the client are not receiving information about approvals or additional notices like that, that is something that USCIS is actively working on and are very aware of. So hopefully this will shift. And I'm seeing in the chat that other people are also receiving this and also seeing this. So it does seem to be pretty widespread, but thus far does not seem to be an actual issue or something that will affect the application itself, but it is still confusing to see, and hopefully USCIS will be able to remedy this shortly. In addition, my last point for this slide is courtesy notices. So for individuals who in theory should have this automatic re-parole extension, thus far they have not received any indication, any paperwork. To my knowledge, USCIS is planning on sending out large batches of notices that do say, this is a courtesy notice to let you know that you are being considered for auto re-parole or that your auto re-parole application is pending, just so that individuals are able to have in their hand further confirmation that re-parole is already in the works for them. And Adonia, correct me if I'm wrong or mischaracterizing that point.
Yeah, from recent guidance, it seems like they are exploring, because I think that's a big question for everybody here in the room. We're a little nervous about folks who have some sort of benefit application pending, whether it's asylum or adjustment of status, whether or not they're actually going to get some sort of confirmation that they're being considered, because people are nervous, particularly as their date of their parole expiration may be looming. So USCIS said that they would consider that. In addition, we received some other updates about the courtesy copy of the 797C parole extension for the legal representatives. And I believe this was shared by Jill Marie recently on one of the listservs. And it indicated that the courtesy copy of that parole extension notice would only be sent to the legal representative associated with the initial C11 EAD or parole-based work permit work authorization document. So I think they're still working out how that information will be getting out to representatives. They have indicated that courtesy copy of the 797C for extension of parole will not be issued to a G28 legal representative associated with just the asylum or the adjustment of status case alone. So what that means in practicality, if you have a client who you filed for asylum or adjustment of status, you've entered a G28, you are representing this individual. If they are considered for this automatic, extension for parole, they won't, you as the attorney will not receive any notification of that. You'll only receive that if you had entered an appearance in on the C11 or parole-based EAD. Sorry, Rebecca, I just wanted to jump in with that because that was kind of late breaking from last week and really important to share for all the advocates and attorneys that are on the meeting today that are wanting to know what sort of information they may be receiving directly.
No, that's absolutely perfect. I knew you would have additional insights on that point. So I wanted to turn it over to you right as I finish this slide and then on to the next. And I think it is back to you, Adonia.
Fantastic. Thank you so much. We are running ahead a little bit ahead of schedule, which is fantastic because I really did want to spend some time on this and playing out the different scenarios. We have some questions here on the slide, and I want to poll the room. And again, there's at the bottom of your screen, you should have a raise hand function. There's also a reaction function that has a thumbs up. Feel free to use that one. I want to go through each of these scenarios and really, let's talk about it as a group about whether or not individuals should be affirmatively filing for the re-parole, affirmatively filing the I-131. So if we can get everybody hands down. All right. So first question, and this is from the perspective of your client. I'm still waiting. Your client's still waiting for a decision on his or her asylum application. And let's be honest, we could also put in this sphere adjustment of status application. Should this individual refile, to file affirmatively the I-131 for re-parole? So again, pending asylum or adjustment, should we be filing that application? So if you think yes, can you please raise your hand? All right, so we have a couple hands up. So in this scenario, based on current guidance from USCIS, they should be evaluating this for the auto extension. You shouldn't have to be under this new streamlined process. You should not have to file anything. You should be evaluated. Your client should be evaluated for the automatic extension on a case-by-case basis. And like we talked about earlier, USCIS is doing this based on when the parole expires. So, this goes back to what Rebecca and I were chatting about earlier. You're going to have a lot of clients and applicants that may be getting a little bit nervous because they haven't yet received any sort of communication from USCIS that they are being considered for the automatic for the extension. But in this scenario, this first scenario, number one, with the still pending, waiting for a decision on the asylum or adjustment of status, USCIS should be evaluating these individuals for the extension. So you should not have to file in this circumstance. All right. So great work, everybody. Let's move on to question 2. Question 2, your client has TPS, but they have not filed for any sort of permanent benefit. They haven't filed for asylum. They haven't filed for adjustment of status. In this case, should your client file for re-parole? If you think your client should file for re-parole, please raise your hands. All right. Look at you. Yeah, we got a lot of hands up. Yes, lots of hands. Fantastic. As we were chatting about earlier, TPS is not a permanent benefit. It is not getting you on a pathway to permanency. TPS, temporary protected status beneficiaries or recipients, aren't going to be considered for the automatic extension. So we really should be encouraging these people to file for re-parole. And beyond filing the I-131 affirmatively for re-parole, we need to talk to folks about applying for what sort of permanent benefit may be eligible to them. So really having that consultation, considering what they're eligible for, assisting them down that pathway. And in the interim, until you can get something filed, absolutely, you should be filing the I-131 for re-parole. All right, great, everybody. Hands down. Let's do it again. So question 3, I have pending SIV. And y'all know this, a lot of people talk about SIV, and that could mean a lot of different things. They have pending SIV, but your client has not filed for adjustment of status. So in this case, where they have not filed for adjustment of status, let's say they have their pending COM. Would this individual need to file affirmatively the I-131 for re-parole? Hands up if you think yes. Hands up. They just have pending COM, no adjustment of status. Oh, I'm seeing some people with 2 reactions, thumbs up and a hand up. All right. Great work, everybody. Lots of hands, lots of hands. I agree with you all in this sort of case, pending COM, but no adjustment of status. Absolutely. You should be working with your client to file for that re-parole, that I-131. How about an approved I-360? Do we get a different result? Are we still filing? Are we still filing that affirmative I-131 re-parole application? Hands up if yes. All right. Looking like we got some hands up. Yes, sir. Oops, sorry, I just shut my window. There you all are. Yes. So on this case, if they have not filed an adjustment of status, that the adjustment of status application has not been filed as of yet, absolutely, you should be filing that affirmative I-131 re-parole application. Okay, so now we're going to get into some like a little bit trickier questions. So everybody hands down. We're going to run into question 4. Hands down, everybody. You guys are a great group. Okay, so question 4. Your client just filed for asylum. Maybe it was just a week or so ago. So recently, the individual has not even received a receipt notice for that asylum application. But the parole's expiring next month. This is a tricky one. Should we refile? Should we file the re-parole, the I-131 application? What are we thinking? Show of hands. All right, looks like we got quite a few hands up, but we're a little split. We got some hands. A lot of you are probably a little bit like me, just questioning and wondering. We are putting our trust in USCIS, the individual with a pending 589 or adjustment of status should not have to file re-parole. But in this sort of situation, it is a little bit murkier. You haven't even gotten a receipt notice. There is some concern that perhaps, it might take a little bit for this to get pinged and put on the radar of the individuals evaluating for the extension. We discuss this a lot internally, and I don't think there's necessarily any harm per se in this sort of limited circumstance where the asylum application is so fresh and the parole is expiring so soon. There may not be any harm in filing the I-131. USCIS has indicated in cases like this where they're going to be evaluated for the automatic extension, but they have also filed the I-131. They will be admin closing the I-131. We do want to be cognizant of government, the resources of USCIS and the pretty substantial lift this is going to be to evaluate all these cases. But I do think oftentimes in this limited circumstance where the asylum had just been filed, haven't even gotten a receipt notice, it would behoove you and maybe in your client's best interest to go ahead and refile the re-parole. So fifth and final question, and you guys have been fantastic with this. Thank you for playing along, is that your client has not filed for asylum or perhaps not even adjustment of status, and their parole doesn't expire until January 2024. What are we thinking here? Are we thinking, should we be filing affirmatively that I-131? Hands up if you agree. Okay, I'm seeing some hands up. Fantastic. I do think this is going to be a little bit of a judgment call, and based on your resources, you really should be triaging cases for folks that absolutely need to file those I-131s right away because their parole is expiring imminently and perhaps they haven't filed for a benefit. I'm sure you all also are extremely busy with your asylum cases and SIV and adjustment cases. So this is a little bit of a resource triage on your end. As we talked about earlier, USCIS has indicated that they are going to be evaluating these cases in order of expiration of parole, which means that they probably, even if you do file that affirmative I-131, because they don't have an application, a permanent benefit application, whether asylum or adjustment of status pending, USCIS has indicated that there's no harm in doing this, particularly this early. They just won't probably get processed for a little bit. So, this is also a conversation to have with your client, a conversation to have in your organization about the best use of your resources. So these last 2 questions were a little bit murky and it could have gone either way. And it's really a conversation with the client and you're based on your resources on this last question, you wouldn't have to apply. If I was you, I would try to use this time to get some sort of permanent benefit filed for your client, if possible, in the next 6 months, and really get them on that pathway to permanency. All right. So I think we're on to Q&A. Okay, so here's a great question. So you have a client who has an asylum case pending, but has also applied for re-parole. Do you think that that's any way negative on his case? And I'm assuming probably either one. Is it negative for the asylum case? Is it negative for the re-parole?
I certainly don't think it's negative for the asylum case. I do think we've heard a little bit from USCIS that it could cause some duplications in their system, or what if one of the affirmatively filed re-parole application was missing something, and then you might get a denial while there's still an actual application pending. So there's just a little room for risk and duplication and maybe accidental denials there. But I don't think at this point we haven't received any clear guidance that it would be majorly problematic.
Rebecca, I agree with you 100%. And USCIS has indicated that in those cases where there's maybe a duplication, they'd be looking to admin close the I-131 that was filed. But I think you raised some really good points about, kind of the duplication of USCIS resources. So another great question, Rebecca, that we have is the 797 receipt notice. Is that enough for the extension, or does it have to be the approval letter? I'm guessing we're talking about the work authorization extension. What's your take on just the receipt notice alone without the approval notice?
Oh, that is a good question. And I'm not sure if I'm 100% solid on that. I would say it's a start to start having that conversation with your employer that this is coming, that they have to respect it if there is the approval in hand. But I'm not really sure. Adonia, do you have a clear picture on that one?
My gut, and this is a little bit where we're waiting for, more clarification and information from USCIS and I-9 guidance. My guess would be is it's going to be the approval notice that's going to be most important to take in conjunction with that expired EAD, because that approval notice is actually going to give you information on getting that updated I-94 document with the new parole extension date and with the instructions to the employer. But yeah, I agree with you, Rebecca. I think there's been it's been a lot of information around this, and we're still learning a lot, and hopefully we'll get additional clarification in the coming weeks between the distinction of the receipt and the approval. Here's a really good question for you, Rebecca. If a client has received the asylum approval, should we still file for re-parole?
Nope. Asylum approval means that you have the permanent status here in the US, so you are set, and re-parole is not necessary.
Fantastic. Here's another really great question. We had some discussions around how on this automatic extension process, you have the option to file for a new EAD. We have a question in here from an individual who submitted the 765 under the C11 category in expectation that they would get an automatic extension. I'm assuming an automatic parole extension for their clients, but they've actually started receiving RFEs for documents asking for the parole extension proof, which kind of makes sense because if it hasn't been evaluated on that case by case basis, the parole hasn't been extended as of yet. What do you recommend? Should they just wait until the clients receive the extensions? Any insights?
In this case, I would wait until the extension is received. I've also seen someone recently who applied for the C11 and had it denied. So that may have just been logistically an issue with other things. But I think at this point, if it's an auto extension coming through, to wait on the auto extension. If it is, you've already proactively applied for both, to wait on that, and that will come through. But my initial hesitancy is that C11 might be difficult because technically, yes, it is an extension, but if you're applying for that alone, typically extensions have a fee associated, and it can be kind of complicated to apply for that without the re-parole piece.
I agree with you 100%. And I think these are some of the like nuanced issues that we'll be getting some additional clarification on in the coming weeks. Well, it's around email accounts, and I'm assuming the accounts associated with my USCIS, and asking whether people have been asking clients to grant them permission to set up and manage their email accounts for purposes of re-parole. Um, I would have a lot of concerns, frankly, about that. Particularly if it's involving the My USCIS account, there are very clear terms as far as who should be logging in and accessing a My USCIS account. I think this question is more around email. I do think this is an opportunity for us to empower our clients and empower people to be able to create an email and check their email. There's a lot of benefits to this beyond just the re-parole process. So at least my 2 cents is to really, put that in the hands of your client, particularly given the terms from my USCIS.
All right. Thank you both, Adonia and Rebecca. I am sorry to say we are out of time. We didn't have a chance to answer all of the questions, but thank you for all of your time and answers. And again, thank you all for attending today. Appreciate your time and attention. And we will be sending out the deck after the session today. Have a good afternoon, everyone.